started for you to be able to go through and help out with estate planning. So we know with what's going on in the world today, a lot of you guys have questions about seeing how this is going to play out. How do you want to leave assets to the next generation or to your spouse? Or, anytime we're seeing problems like this, we see that there's questions always surrounding it. And Brad's going to help us out with looking at what's true and what's false when it comes to estate planning. This is one of the things that comes up often when we're doing our planning. So this is obviously one of the biggest ways that we see things getting messed up when you enter into retirement. So we'll be getting started here in just about 5 more minutes. All right, I see a couple more people hopping on right now, so appreciate your time to be able to join us here at lunch. So we're going to be getting started promptly at noon. I've got Brad here with us, who's long time been with the Life Wealth Group, and many of you have worked with him through estate planning. For those of you unfamiliar with Brad, Brad's been on our team now for almost a little over 10 years. So it's been amazing. It's been a decade now of helping out families here in Central Florida and around the country. But Brad changed gears a couple years ago, moving with more of a focus in estate planning to be able to help out with that gap and concern in people's plans. So Brad will be going into more detail, showing you what's true, what's a myth when it comes to estate planning. We saw a lot of sweeping changes with this at the beginning of the year with the Secure Act. So a couple months ago, that's what our Lunch and Learn focus was on. If you were unable to attend with that, you'll be able to go back and listen to that recording on our website. If you're unable to view that, simply reach out to me, Andy, A-N-D-Y, at lifewealthgroup.com, and we can send that link to you to be able to watch and see what exactly is the Secure Act and how does that affect you outside of just estate planning. So we want to make sure that you're making the best choices with that. So as we get ready to start here, just a couple basic housekeeping items for you. On the right-hand side, you should see a link where you can hit chat. We know that this is a area that a lot of people have questions on. And at the end of our presentation, we'll have a time to answer a few of those questions you might have, as long as they're not too detailed. When we get into individual and specific questions that you may not want to address in that chat window, that's stuff that we can cover with the time that Brad has been kind enough to set aside to have some basic conversations with you to help out with any gaps or concerns you might see in your estate planning. So there'll be a time that you can go through that. There's also a link where you can go directly to my calendar where we can sit down and just do a basic beneficiary audit. We want to make sure that your accounts are positioned to go to the people you actually want them to go to. That's one of the biggest things that we see as a problem when it comes to estate planning. Those things get out of date. So if that's something that you want to take advantage of, you can click on my calendar. We can quickly handle that either in person if you want to, or virtually through a Zoom meeting like what we're doing today. So that's an opportunity that you have. All right, so my watch shows that we are 12 o'clock. We're going to go ahead and get started so that we can make sure to use our time wisely. So like I said, my name's Andy Young, one of the financial advisors here at the Life Wealth Group, joined by Brad Busbin, also one of our financial advisors, but also a practicing attorney when it comes to estate planning. So Many of you are familiar with Brad. For those of unfamiliar that were not on the introduction there, over 10 years with the Life Wealth Group has shifted that focus to being on estate planning to be able to help out with that gap and concern in the plan. So a lot of people, when it comes to planning for their future financially, they look at, do I have a retirement income plan? They're looking at with their investments, how those are positioned and where they are. They're looking at tax planning. And we can do all of those things and do them very well. Healthcare planning. But the last and final piece with that to really complete the puzzle is estate planning. Now, there's a lot of misconceptions when it comes to this. So we want to make sure that we're going through this to help out with what's true and what's false for you and your family to protect you. So without further ado, I want to welcome Mr. Brad Busbin to the conversation.
All right. Thank you, Andy. Thank you for everyone for joining us. I look forward to hopefully sharing a little bit of insight to you and clearing up some of the truths and myths behind estate planning. So we're just going to go ahead and get started. We're going to first get to our disclaimer here in a second. As always, technical difficulties. Sorry about that, folks. There we are. Real brief disclaimer for everyone to review.
So with everything that we're going through, guys, as you know, this is going to be generalized information. You've got specific stuff that's going on in your world, and we don't want to use this as blanket statements to tell you to go take action. If you've got specific questions, set a time so that we can sit down and chat and figure out what's important with you. So again, Brad's been kind enough to set aside limited time on his schedule that we can have some introductory conversations about estate planning, do a review with myself to see with your beneficiaries, are we in line, and do we recommend to make any changes?
All right. Thank you, Andy. So let's get in and we have a little bit of clarity or confusion here. So what is probate? Probate is the process of transferring your assets to those that you want them to receive. If you have a will, your will expressly tell the court who receives your assets. If you don't have a will, your assets will pass through what is called intestate succession, which means the state of Florida will decide who in your family gets your stuff. So let's continue right on. Some of the common myths. First, having a will avoids the probate process. That is a myth, okay? Like I said, the will just instructs the court who is to receive your assets. Even though you have a will, it does not avoid the probate process. So anything that does not have a beneficiary designation or is designed to pass outside of the will has to go through probate. So having a will does not alleviate the burden of going through probate. And probate, honestly, it can be a timely process. The fastest I've ever been able to accomplish a probate was about 4 months. But I have a couple of probates that I'm currently working on right now that are past the 1 year mark. And if it's a complicated estate, if for any reason there's a will is being contested, it can extend the time. Additionally, if assets are hard to value, it may take longer time to actually go through and complete the probate process. Next myth is if you die without a will, the state gets your property. That is also a myth. The state does not actually get your property. Like I said, if you die without a will, the state of Florida has a statute designed for what they call intestate succession, which means you died without a will. And it specifies who receives your assets. If you have a spouse, if you have children, they will be included. If you wanted to leave to potentially someone outside of spouse and children, most likely they will not be included. So it's really important to make sure that you're taking the time to plan things out right. And honestly, if you can plan in such a way that you avoid probate at all costs, that is obviously the best way to go. Make sure that your wishes are done appropriately. Additionally, if you avoid probate, your wishes are left private. If you have to go through probate, at the end of it, it is a public record and everyone will know who got what from your estate. So, next myth is you can leave property. You can leave your property to anyone you want. Well, you can. That is not actually a myth. You can leave your property to anyone you want. If you, through the process, through doing a will, you can leave outright to anyone. It does not have to be just a family. It can be to friends. It can be to charitable organizations. It could be to your alma mater. Anyone that you want to leave to, you can. You have that. So that is not a myth. You can actually leave to whoever you want. The important thing is actually taking the time to plan that, though, because like I said, if you don't plan it, the state decides who gets your stuff. So if you wanted to leave money to someone and you haven't designated them appropriately, it's not going to get to them. So taking the time to plan out who you want to include, who you want to transfer your wealth to, is an important step. And once it's done, then you are ensuring that those individuals or those organizations are going to be included in your estate plan and receive what you want them to receive. The probate process can take several years. It can. Like I said, I have multiple probate estates right now that have been open for over a year. Some instances we have people contesting the will. We have, so if we've got a will and someone is left out, or I've got a case right now where I've got 2 children were completely left out and they're trying to fight, saying that the will was done with undue influence or under duress and that should not be valid at this point in time. So it's important that the will be executed properly. This will was executed in a manner that followed the accordance of the law. So it is a will, but the environment which it was signed in is why the other side is questioning it. It is a valid will, and I stand behind it being a valid will, but there are children that are fighting it currently. So, next. Most debts are wiped out upon death. This is not necessarily true. Any debt you have, with the exception of student loans, some student loans will be wiped out upon death, but your creditors become creditors of your estate. If your assets pass by will through the probate process, if they are not an exempt asset, those assets would be subject to attachment by your creditors. So if you have assets that, let's say you had a savings account that you wanted to leave to someone, and it was an individual account, and you wanted to leave it to a child, and you left in your will that account goes to your child, and you had a creditor that had a claim that was equal to that amount, well, there's a chance that creditor could get paid that entire amount. Now, creditors have a certain period of time in which to file claims. If they do not file within a certain period of time, then they are barred from filing their claim forever. So most debts are not generally wiped out upon death. Very few, in fact, are, and those creditors could be creditors of your probate estate. Now, those creditors can only attach to assets that go through the probate estate, which is why it is extremely important for you to pass money outside of the probatable estate. So with proper planning, you can ensure that money passes outside of the probate estate and thus outside of the reach of any of your creditors. estate creditors are first in line to collect money from estate. So this is not true. There are some creditors that do stand in line to collect first. Some of those creditors would be funeral expenses. Funeral expenses are a priority level creditor. There are 8 classes of creditors. U.S. income tax or U.S. tax debt, that's a priority creditor. A general creditor, a credit card, for instance, is a class 8 creditor. They are one of the last to be paid. A medical provider that provided services within 60 days of death, they are a priority creditor. So there's different levels of priority. There is also a point in the probate where the family can get what is known as a family allowance, where money can come out to the family before those class 8 creditors would be satisfied. So some creditors do have preference, but not all of them, and some money will actually escape before any creditors are actually paid. So you can avoid probate with a living trust. This is true if, this is an if the trust is properly funded. Going to see someone and creating a trust document is great. It is the first step, though. If you do not actually fund the trust, and by funding the trust, I mean making sure beneficiary designations are pointed to the trust, assets are placed in the trust. If these steps aren't taken, then having the trust makes it a very expensive stack of paperwork, and it doesn't actually do what you want it to do. So it's one reason the Life Wealth Group and I work very closely together is after your estate documents are done, we work to make sure that your assets are coordinated so that upon your passing, if you have a trust, the things in your trust are going to pass outside that probate estate. And that's a very important thing to, so we want to, once again, make sure that we're having as little as possible go through probate. All right. Things that are, let's see, are these subject to probate? Individually held assets and accounts. So, like I said, if you have an individual account, or let's say you have a joint account with a spouse, at the passing of one spouse, that account becomes an individual account. Well, if that account does not have a transfer on death or a pay on death designation, it's an individual account. Upon the passing of that individual, that asset would be subject to being subject to probate. It would be frozen and become what is known as an estate account. And a probate administration would have to be started in order to get these assets through to those that you wanted to receive them. Other things that would be subject to probate: IRAs, 401ks, 403bs, life insurance, and annuities without a contingent beneficiary. See, all of these items have beneficiary designations. So typically, people will designate their spouse as a beneficiary on their account, but they may not go back because for whatever reason they don't have the date of birth or social security numbers of their children, and at the time they start the account, they may not add them as beneficiaries on these accounts. The problem comes in that if your spouse predeceases you and now you have no beneficiary listed on that particular account, then that account is going to end up being part of your estate. So the IRA company, the 401k provider, the life insurance company, or the annuity company is going to say, no, there wasn't a beneficiary on this account. It needs to be payable to the estate of the individual. And to do that, you have to start a probate process and have a personal representative appointed so that you can, get those assets, or so that your children can get those assets over to them right now. Next, second homes. So if you have a home, actually any real estate property, for instance. So in Florida, we have what's known as homestead exemption. Houses we live in, we get protection. It's homestead property. That house, your homestead property, can pass through probate process, but it's not subject to the reach of any creditors. It cannot be forced to be sold. So it goes through probate, but it's not subject to the reach of any potential creditors. But any secondary properties, say you have a house here in the city, and then you've got a house at the beach, or you want to get away from Florida during the summer and you've got a house up in the mountains of North Carolina. That second property, if it's not titled correctly, is going to create a probate situation. And if that property is in another state, it's going to create not one, but two probate situations, because there will have to be a probate in the state where that property is located, and then a probate in the state of Florida. So you have to close out the probate estate, the probate where the property is located, move the assets to the probate in Florida before they can be distributed. So creditors have multiple opportunities to get access to the value that's in that home. So this particular properties would be subject to going through probate. If you have a house that's in your individual name or joint with your spouse, and it is a secondary property, the value you have in that home could be subject to the reach of any creditor you have upon your death to satisfy those debts if that creditor files a claim. So next, what avoids probate? So we've got joint accounts with right of survivorships or tenants by the entirety. So joint with right of survivorship can be, it's available to anyone. You can have a joint with right of survivorship with any other person. There's no requirements. It can be a friend, a spouse, a child, a brother, a sister, a parent. Tenants by the entirety, this is a type of account designation that is only allowed with spouses. Something unique about tenants by the entirety designation as well. Accounts that are designated as tenants by the entirety, if one spouse gets sued, the assets held by tenants by the entirety are given a little bit extra protection, because both spouses would have to be sued in order for those assets to be subject to the reach of that creditor. So gives a little extra protection there. 401ks, IRAs, 403bs that have contingent beneficiaries, they pass outside of the probate estate. You have made a contract with those institutions which says, upon my death, I want these individuals to receive my assets. There's also this little bitty box at the bottom of them generally, which is called per stirpes. If you check that box, it ensures that if that person passes, their share will then go on to their children. Life insurance and annuities with contingent beneficiaries, once again, just like the 401ks and the IRAs, you have entered into a contract with these companies and you have told them upon your death you want these assets to be paid somewhere. Those do not come into the probate estate, they stay outside. Transfer on death or pay on death accounts. These can be attached to any joint or individual account, whether it be brokerage, savings, checking, money market account. Your banks generally will not tell you this information. In fact, I have only had one bank in my experience in dealing with numerous banks which has ever offered to add a transfer on death designation to my account when I opened it. And that is important. By adding a transfer on death or pay on death designation to those types of accounts, you have added a beneficiary designation to that account. It moves outside of the probate estate. So you are saying upon your death or upon the death of you and your spouse, you want those assets to go to those individuals. They will go directly to them. No need for probate. Those assets go directly to them. Now we're going to get into a little bit exempt assets. So automobiles. 2 automobiles are exempt assets of probate. Generally, if a automobile is the only asset you have, there is a short version of probate called Disposition of Tangible Personal Property without administration. And this is for basically estates that there's only tangible property and it's less than, I think it's $6,000 off the top of my head. You can actually move those assets outside of the estate. So if you have a car, once again, we're looking at, trade-in, resale, garage sale value, we can move that car generally by that type of probate. It's an exempt asset. It's not subject to the reach of any of your creditors. 2 automobiles per person are considered exempt assets. Then homestead property. Like I said, your homestead property is an exempt asset. It has to go through probate, but a creditor cannot attach to it, and it gets assigned a $0 value for a $0 value in the probate estate, and a creditor cannot attach claim to it. $20,000 worth of furniture and furnishings are also considered exempt property. So this is includes your tangible personal property. That will be exempt as well. And then finally, assets held in trust. Once again, a trust is outside of probate. Assets are held in a trust, do not go through probate. They are distributed according to how the trust instructs the trustee to do that. If you have concerns about, your assets potentially going through probate, looking at and discussing, does a trust make sense for you, would definitely be something that you should do. You can talk to Andy, or we can schedule some time for you to talk with myself and see if a trust actually makes sense for you, and make sure that works for you. So what now? Okay, as Andy said, we have recently, as of January, the Secure Act came into effect. And the Secure Act does have an effect on your trust being a beneficiary of your IRA. Previously, if you had your trust named as a beneficiary of your IRA, it would take let's say you had 2 beneficiaries of your trust, it would stretch it over the life expectancy of the oldest beneficiary. So if you had 2 children, one was slightly older than the other, it would distribute the assets based upon the eldest child's life expectancy. So that wasn't much of it was a good thing. It helped allow to stretch out the benefit of the IRA, keeping that qualified status so that income tax wasn't, the whole amount wasn't taxable at once. So with the Secure Act, that has changed. So right now, the Secure Act has limited any inherited IRA is shortened to a 10-year distribution period. So inherited IRAs for non-spouses have to be distributed over the course of 10 years. It doesn't have to be once a year for 10 years. It could be all in the 10th year. It could be, a little bit every year. It could be every other year. There's no specific language on when you have to take the money out, other than it all has to come out by year 10. Now, it's qualified money, so it's going to be taxable as income when it comes out. So this has made a little bit of a change and threw a little bit of a hiccup into a couple of estate plans where individuals had large IRAs and were naming their trust as a beneficiary to make sure that the assets got to their children, were divvied up to them in certain ways. So right now we're going back through and looking at how that change in the law affects a couple of these estate plans and the appropriate fixes for them. So we want to make sure, does it make sense to still keep the IRA as a beneficiary of the trust, the beneficiary of an IRA, and what changes we can make to the trust to make sure that it continues on with the same way that you want to make plans. So right now we're looking at that. So we're still planning on doing that so that we can still achieve that stretch out of distributions from your IRA. So so that's what we're looking for at this point in time. We want to make sure that we still plan in such a way that distributions are stretched out, because your beneficiaries of your trust may not necessarily be ready to handle such a large distribution, especially if you have a large amount of money in qualified accounts such as IRAs or 401ks. So.
All right. So, Brad, appreciate your time to be able to go through and give us a little bit more basis as far as what's going on in the world of estate planning. And just as he hit on there at the end, there are some old tools that work to solve the problems when it comes to the distributions with your IRA. That comes back a lot to the plan. So when we initially met with all of you that are on the line, and we went through that Life Wealth Dream Builder process, we were starting with the plan first. We're trying to see how much money you have left for an impact at the end of your life. And if you see that a lot of the money is positioned that it's going to be qualified money from your IRA, from your 401k that's left, we have an opportunity to help out not only on the estate planning, but also on the tax planning, finding ways that we can help move that money from an environment where you're going to pay tax on it to where we can move it, the growth and the future value is going to be tax-free to pass to the next generation, your spouse, whomever that might be, so it can make a bigger impact. So if that's something that you're interested in having a conversation, click the link to the side so that we can schedule a time to be able to go a little bit deeper with that. At the Life Wealth Group, we believe in continuing to educate you. So the upcoming things that we have going on the 24th and 26th, Disney World might be closed, but Moonfish is open. We are going to be sitting down and going through. We have a lot of you that are already bringing friends and family with you to those 2 nights. But we're going to be going over. It's a fantastic introduction event. So if you have somebody that you care about, that you feel, especially in the market environment that we're in over the last 3 weeks, could benefit from a voice to help them through this process, that's a nice, easy introduction. Come have dinner on us, enjoy the event, and be able to find out some more information of what they can be doing right now to take advantage of that. We're also going to be having a quarterly market conference call. I'm going to have to test and see how many people this system can hold. I have a feeling that one's going to be well attended. It'll be on May 1st. We do have a lunch and learn event coming up just like this, May 8th. We know that time of year, a lot of kids are getting out of college. A lot of the colleges have already sent the kids home for the rest of the semester to work on their classes online as opposed to on campus. But for those of you that have kids that are in high school, middle school, elementary school that are trying to figure out, how do I pay for their college? It might be a grandparent trying to see, how do you chip in? This is going to be a great event for you. And lastly, this is a fantastic event that we go to every year. The gentlemen that are members of the Life Wealth Group family, the Better Man event. So this is put on every year. Last year we were at the CFE Arena at UCF. This coming event in May will be at the Silver Spurs Arena down in Kissimmee. So we'll be going with that. A group of us will be attending. If you're interested, contact Susan at her office. So just call the main office line, 407-299-4129. Speak to her and let her know you're interested so we can send you information. Wrapping up, we appreciate your time and allowing us to be able to help you and your families out. We know in everything that we're doing, this is why we plan first and do everything else second. If you have questions about your plan and how things fit together, not just estate planning, but looking at your income design, your retirement plan, reach out to us so that we can help you out. The link is to the side that you can click to be able to schedule a time with myself to review any questions that you've got, or call the office at 407-299-4129. If you'd like to schedule a time to sit with Brad, you can reach Brad at brad@lifewealthgroup.com. Or call our office so that we can give you the number for his main line at the legal firm. So we appreciate it and hope you have a fantastic weekend.